Hi, welcome to the fifth episode of the Utsav Mukherjee Intellectual Property and Technology Law Show. Today's episode is about something very interesting that I'm sure that most of you are going to enjoy listening to, especially if you like playing online games that involve betting, or on the contrary, absolutely detest such games and think that they should be firmly regulated. So today's episode is about gaming laws in India and very recent developments on these laws. So the games that these laws are on include fantasy sports. And fantasy sports is one of the fastest growing industries today. And today's episode is not only interesting for all of you, it's very interesting for me as well because it involves aspects of constitutional law and laws on betting and gambling and the IT rules. So, some these laws are very interesting areas which I personally like. Now, for those of you who are watching my show for the first time, I'm an intellectual property and technology lawyer based in Delhi, and I'm affiliated with a law firm here. So, any of the views or opinions that I express in this video are mine alone and not that of any other person or entity. Now, before we get into the details of the recent developments on this front, let me give you a brief overview on the subject matter. In India, lawmaking is divided between the center and the states, right? And different subjects are divided into different lists. There's the central list, there's the state list, and then there's the concurrent list. Now, when a subject matter falls within the center list, only the central government or the union government of India can make laws on it. When a matter falls within the state list, only state governments can make laws on it. And when something falls within the concurrent list, both the center and the state can make laws on it. So, as far as betting and gambling laws are concerned in India, they typically fall within state lists. Right. Now, most of these laws get complex since gambling laws are pre internet and hence they did not typically address modern gaming apps and fantasy. So, there is typically nothing that gaming law specifically falls into. Like, the gaming law doesn't fall into central list or state list or concurrent list. It's the laws on betting and gambling that fall within the state list. So, that's why different states have different laws on gambling. So, now this is where the work of IP tech and gaming lawyers and public policy professionals comes in. The laws around online gaming have evolved over a period of time, and court judgments and different developments have spawned on this area. So, all online games that involve betting do not fall within the same category. There are games of skill and there are games of chance. So, a game of skill is one where victory or loss in the game depends upon the player's application of skill and strategy adopted, or expertise in the game. A game of chance, on the other hand, is one where victory or loss depends entirely on the probability or chance and not on any application of skill. So, courts have held that where a game involves, any kind of application of skill, and even if it does involve some element of chance, it would still be considered a game of skill and not a game of chance. So, for example, poker, right? This is a game which involves both skill and chance, but it would be considered a game of skill. And there were some very recent amendments that were brought about on the idea of online gaming to the IT rules. So before this, there was no actual proper regulatory framework on gaming laws. So very recently, the IT rules, which is actually falling under the IT Act, the Information Technology Act, a central legislation, brought about rules under it called the IT rules, right? The MIT, the Ministry of Information and Technology, brought about these amendments to the IT rules. So this is because even though betting and gambling are state laws, are falling within the state list, online gaming is an IT subject, and this falls within the center's domain. So basically, these amendments that have been brought about to the IT rules on online gaming will now be read with the state laws on betting and gambling. So there have also been other developments prior to these amendments to the IT rules. And before I start on the amendments to the IT rules regarding online gaming, let me tell you about these prior developments very briefly. So, the Advertising Standards Council of India, or the ASCI, which is a regulatory body on advertising in India, released certain guidelines on advertising for online gaming and fantasy sports in the year 2020. So, these guidelines said that a disclaimer should be given along with advertisements for such games saying that the game should be played at the own risk of the player and it involves financial risks and may be addictive. Further, the ASCI guidelines said that an advertisement should not present online gaming for earning real money as an income opportunity. It is also said that the guidelines should not suggest that a person involved in gaming activities is more successful than others. And the ASCI released an advisory against ads promoting online betting websites or platforms in both print and digital media. This was done in public interest due to the financial risks and issues of addiction that these games involve. This advisory was not applicable to domestic operators of skill based online real money games such as poker, rummy, and fantasy sports. It was applicable only to rogue operators, largely foreign websites which had no permanent establishment in India. However, even after the release of this advisory, hundreds of ads of fantasy sports are found to be in violation of these guidelines. Then, after there was another important development in the year 2022 when a decision was given by the Supreme Court of India holding that fantasy sports were games of skill and not games of chance. And then in December 2022, the Ministry of Information and Technology, or the MIT, was designated as the nodal ministry to oversee online gaming industry in India. And further, esports were brought under the purview of the Ministry of Sports and Youth Affairs. So these were some important developments in online gaming, right? Before the most recent amendments to the IT rules. And also, there was an online gaming regulation bill of 2022 which was introduced, but this is still under review and has not yet been enacted. So, now that we're done with all these prior developments, let me talk about the latest amendments to the IT rules on gaming laws. So, these rules will apply to online gaming intermediaries, right? And let me first tell you what an intermediary is before I explain the meaning of an online gaming intermediary. An intermediary is a platform on which content is posted or across which content is exchanged. So, an intermediary does not itself create any content or modify any content. It is just a platform over which content is exchanged, right? So, an online gaming intermediary is an intermediary that is also a platform which enables access for users to online games. So, to my understanding, since this definition of online gaming intermediary is quite broad, any online app or social media app, internet service provider, which enables users to access online games would fall under the definition of online gaming intermediaries. And this is a very, very broad ambit if you ask me, right? There are some other important terms also that have been added to the IT rules on online gaming. And one of these is on the term online game. The term online game has been defined as a game that is offered on the internet and accessible by user through a computer resource or an intermediary, right? It's quite plain, straightforward and simple. Then the term online gaming self-regulatory body has been added, which means that there will now be a self-regulatory body for online gaming. And the term online real money game has been added, which means an online game where user makes a deposit in cash or kind with the expectation of earning winnings on that deposit. And further, the terms permissible online game and permissible online real money game have been added. So, permissible online game here means an online game that is allowed. Permissible online real money game means an online real money game verified by an online gaming self regulatory body. And this means that only those real online money games will be allowed which are verified by an online gaming self regulatory body. And the self regulatory bodies would decide on whether or not to verify or allow such money games on the basis of standards set in the IT rules itself. So these rules have also set the parameters to be followed by self regulatory bodies, right? Or the parameters that any body must meet in order to be a self regulatory body under these rules. First of all, the self regulatory body has to be a company registered under Section 8 of the Companies Act. This means that they have to be non profit companies or companies formed for a charitable purpose. Then, they must be present in the gaming industry. So, they must be providing online games and promoting them in a responsible manner. Further, it is important that these bodies have sufficient finances and infrastructure in place to actually carry out their functions. And the board of directors of these online self regulatory bodies for online gaming must have special knowledge or practical experience in online gaming. So they must have a good reputation, right? These directors and no conflict of interest with their function. Now, the rules for the functioning of these self regulatory bodies will be contained in a memorandum of association and articles of association of the body itself, right? And these self regulatory bodies are also supposed to maintain details on their website. For instance, their website must show details of their grievance addressal mechanisms and the officers that will perform this function, and they must have an updated list of all online permissible real money games which they themselves have verified. So they must show the framework for such verifications to maintain transparency. So what I mean to say is that they must show what parameters they're following to verify online real money games as permissible, right? So now let me tell you about some of the key elements that these frameworks for verification of online real money games consist of. It must be verified that the game is not against the sovereignty or integrity of India or the security of the state. There must be safeguards in place to prevent harm to users, right? Physical or psychological harm. And there must be safeguards to prevent addiction, fraud, or harm to children. Now, let me tell you about the obligations that the amendments to the IT rules have cast upon these online gaming intermediaries. For starters, they must display a mark of verification on the online games, which have been given by a self regulatory body. And they must inform users of their own rules and regulations, privacy policy, terms of service, and user agreements. They must also inform users of the policy on deposits, refunds, and withdrawals, any fees to be paid by users, KYC processes, and framework for verification of online games. They must also inform users of their own contact details, grievance addressal mechanism, and grievance officer details. They also have to enable users to verify their own accounts. Now, they must keep information secure by keeping standards of compliance with the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data Information Rules of 2011. Right? They must report cybersecurity breaches and incidents with the Indian Computer Emergency Response Team as per the IT certain rules, right? So the certain rules are basically to prevent cybersecurity breaches. So these intermediaries will have to report any such cybersecurity breaches in simple terms, is what I mean. And they'll have to, keep proper security practices and procedures in place as per the relevant rules under the Information Technology Act, which I just mentioned before. So they also have to ensure privacy and transparency on their platform for users, right? These are some of the main functions which I just spelled out. And as you can see, these functions or obligations provide a broad regulatory framework for online gaming in India, which has to be applied along with the state law. So the framework or these guidelines, obligations under the IT rules have to be applied along with the state laws on betting and gambling. Right. So as I said before, online gaming rules under the IT rules under the center and state laws on betting or gambling will have to be read together and applied together. And I see this as a positive development, considering that the broad parameters of the regulations of the subject should be kept common in all states, right? Considering that this is now an issue which affects the public at large and needs to be taken very seriously. And online gaming is now an important source of revenue also for both the national and state economies, right? So it's very good that these rules are imposing a certain level of accountability on online gaming intermediaries, considering that there are issues of self-harm, of addiction in online gaming. There are serious issues that need to be tackled. So a broad regulatory framework is a very, very good initiative, right? But the only problem that I see with the rules is a very, very broad definition of online gaming intermediaries, right? So the rules apply to a very, very broad set of entities. The online gaming intermediaries would include any entity which enables access to online games, right? So this would include both, an internet service provider or a social media app or a Play Store. So it's too broad, right? It should be a bit narrower. We cannot cast responsibility on so many entities. And a plain reading of the amended rules, makes it very, very clear that this is too broad a net and this needs to be narrowed down. But nevertheless, it's very, very good that they have at least put forward some rules to be followed, which would, now clear the ambiguity and regulatory uncertainty that existed before. So it's a time can only tell us whether these amended rules would work well in their actual implementation. But I think this is very, very good for a start, and the regulatory framework will evolve and develop with time, right? So thank you so much for listening into this episode, and please do give me your feedback in the comment section of this post. I look forward to bringing more and more exciting episodes in the IP and tech law space. Thank you so much.